Welcome. We're going to be talking about California nationalism as we interpret it, displayed by various California legal scholars from the top legal universities in California. We're going to be talking about how legal scholars at the Constitutional Center at Berkeley Law and legal scholars at Stanford Law School both took a stance recently in the last couple of years that we would interpret as being more California nationalist, obviously based within the confines of the Constitution and American and California legal dictums, but California nationalism nonetheless by legal scholars. So we wanted to point out that this is happening. But first, okay, thank you very much. So we're going to be talking about these two documents today. The first one is an argument for zero-based state constitutional interpretation by Nick Scheuerman by Berkeley Law at the California Constitution Center. The other one we're going to be looking at is What If California Had a Foreign Policy? The New Frontier of States' Rights by David Freeman Engstrom and Jeremy M. Weinstein. One of them is from Stanford Law School and another is also from Stanford, but the Political Science Department or International Department. So this document basically says that California should interpret the California Constitution independent of the United States Constitution. An argument for zero-based state constitutional interpretation, again, published in the California Constitution Center at Berkeley Law. And here's what it says. Article 1, Section 24, the California Constitution states that rights guaranteed by this Constitution are not dependent on those guaranteed by the United States Constitution. Nevertheless, the California Supreme Court generally does not interpret the California Constitution independently. Instead, the state high court generally follows the U.S. Supreme Court's interpretation of analogous constitutional provisions unless there are cogent reasons not to do so. That is the wrong approach because it violates the will of the California voters to have the California Constitution serve as an independent guarantee of rights and that defends the California independent sovereignty from the United States. I want to repeat that. That is the wrong approach because it violates the will of the California voters to have the California Constitution serve as an independent guarantee of rights from the American Constitution, and it defends the California's independent sovereignty from the United States. California courts should adopt a zero-based method of constitutional analysis by actively ignoring the federal Constitution and federal case law when interpreting California's Constitution. Zero-based interpretation is appropriate for California because it would give full effect to California's sovereignty. And here's the Berkeley Law California Constitutional Center. They're one of the experts on the Constitution here in California. This article was written by one of the writers there. And this was a quote that got me. Zero-based interpretation would give full effect to California's status as an independent sovereign with plenary powers over its own affairs. Each state has always had its own constitution and unique individual right guarantees. Nor was the Bill of Rights meant to supplant rights guaranteed by state constitutions. Instead, it initially only limited action by the federal government, not the states. Even when the 14th Amendment was ratified in 1868 with the requirement that states not deny due process to individuals, it took until the 1960s for most of the Bill of Rights guarantee to be incorporated to the states. Thus, for much of California's existence, the state constitution was the sole guarantee of rights. So what they're pointing out is the federal government may ensure rights, but they're rights that the federal government has to provide, not that the states have to provide. When you look at it that way, a lot of the civil rights that we've come to expect in California were protected by the California Constitution up until the 1960s. It wasn't until the 1960s when the federal Constitution began to protect rights. Up until the 1960s, rights were protected in California by the California Constitution, not the federal Constitution. That was new to me. I thought the federal rights were ubiquitous and everybody had to follow them. This is saying federal rights were guarantees of federal law, that the federal government had to ensure these rights. They did not say that states had to ensure those rights. So if you look at it that way, For most of California's existence, our Constitution has been the sole guarantee of our rights, not the federal Constitution. We depended on ourselves, and we should do more of the same so that we could facilitate our own independent sovereignty, as put here. That's a very nationalist interpretation, one completely based upon the law, but one that a lot of Cal-Exit supporters would love to support. I mean, the guy's clearly talking about California being more independent-minded to the extent that it can within the confines of the U.S. law. And it's saying we should call on ourselves and count on ourselves more. And it's also saying, you know, really, it wasn't America that protected our rights. It was us Californians that protected our own rights. That's from this document here. That's included in the description. You can click on it and read it yourself. Okay, the next one. California should have its own foreign policy. Now, as you know, the federal government, particularly the federal president, determines foreign policy. These guys are saying California should have its own foreign policy, independent of the federal government. Though some legal constraints remain, the Trump presidency has spurred and will likely continue to galvanize a range of new efforts by California and other states and municipalities to test the limits of federal power in foreign affairs. Californians are proud of their commitments to diversity, the environment, and human rights, and set them apart from what they see emanating from Washington, D.C. Californians are proud of their commitments and that they see as different from what's coming from Washington, D.C. under Trump. States and cities differ in important ways as well. In particular, governors and mayors are elected representatives of a geographic constituency with a mandate to advance that state's or region's particular interests. When those interests are poorly served by the federal government's foreign policy, the pressure to act in ways that challenge the federal government's preeminence can be irresistible. Seeing that here. One voice idea is a convenient shorthand, but the legal case in its favor is hardly ironclad. Begin with the text of the Constitution itself. True, the framers plainly prohibited certain state actions. States may not engage in war or make treaties, and they may not enter into compacts or agreements with other states, whether domestic or foreign, without Congress' permission. But the textual case for the one voice concept otherwise lacks much punch. To begin, the Constitution sprinkles foreign affairs powers across both the legislative and executive branch. Congress gets to regulate foreign commerce, define offenses under international law, declare law, and raise and regulate the military, while the president is able to do other things. The million-dollar question, as California and other sub-federal governments move on to the global stage, are just how far does the defensive halo extend as the degree of federal-state conflict weakens, or in the current context, where the federal government has left the field altogether and has no policy at all. So what they're talking about is this one voice idea. It's an interpretation that only the president can do negotiations with foreign nations because only the president can sign treaties with foreign governments. However, these legal scholars from California say that's just an idea. Yes, the president can sign treaties and is the only one. But the concept that only the president of America can do foreign affairs is incorrect because Congress does foreign affairs. It regulates foreign commerce. It defines offenses under international law. It can declare war against a foreign government. So Congress had the ability to do foreign affairs in addition to the president is what they're saying. And this idea that only the president can do regulations for foreign affairs is incorrect. It's a theory, and it's not based upon the actual construction in the U.S. Constitution. Then the next question is, where can California start to exert itself in the foreign policy field? Given that there really isn't a constitutional legal framework saying that only one office can do it. Is it where the federal government has left the field together and advocated no foreign policy at all? Is that where states can jump in when there's a complete gap of leadership in foreign affairs? I like this quote, but it's also important to note that enthusiasm in states and cities to exercise leadership on the global stage has long in the making. It will not go away when Trump does. So California acting like a nation will not go away when Trump does. We know that's true because California still continued to travel around the world. Our Governor Newsom under President Biden, who's not Trump, continued to make climate change deals with foreign countries. And he also ignored federal regulations, I believe, on masks that came from the Biden administration, proving this theory that enthusiasm for being independent, especially on the global stage, will not go away when Trump does. In an environment of strong bipartisan agreement on major national security priorities, few are concerned about activist states and municipalities. With a shared sense of direction, the energy of sub-federal actors was seen as a virtue, opening up new tools and channels for advancing U.S. interests. But with the loss of that bipartisan consensus, the likelihood that the federal government and states may act at cross purposes is increasing, and the incentives for pushing the boundaries even stronger. So what they were saying is, for a long time, everybody kind of agreed with what we're supposed to be doing. But now we don't have a consensus that goes across both parties. We're very divided, unlike we've ever been. That's what they're pointing to. And so since we're so divided, can we really count on the federal government to take care of state interests at the international level when we all kind of agreed? Now that we don't all agree and we don't have consensus and we do have differences of opinion, is it fair to say that the federal government will cover all the international relations and activities that California wants? Not really anymore. But tucked in the decision was a sleeper. In striking down the law, the court said its analysis may be different where a state was acting with its traditional competence, and further, the analysis of federal-state conflict would turn, at least in part, on the strength of the traditional importance of the state concern asserted. For a state like California that is fast moving into climate space, this is manna from heaven. Indeed, the Supreme Court said more recently in 2007 case that Massachusetts, as both a sovereign and landowner, has powerful long-standing interest in protecting its shorelines against the rising sea levels that come with climate change. Of course, this argument may not wash, so to speak, in landlocked Oklahoma, but for coastal states like California, it provides a ready-made defense to a one-voice challenge to state action. As states and cities move onto the global stage and attack global problems, expect them to frame their efforts as local efforts to protect people and property, the core of the state's traditional time-tested police powers. As they do so, the distinction between what is foreign and domestic will blur and could fall away entirely. Further undermining the one voice idea in the climate space and perhaps even beyond is areas like immigration and human rights, where states can plausibly point to concrete interests. So what they're saying is, when the state has compelling interest to protect its people and property and life and action, they may be able to go into the foreign policy space and support certain policies that the federal government would not. And they might be able to win that argument because they're doing their basic job. States and cities may move onto the global stage and attack global problems, but expect them to frame their efforts as local efforts to protect people and property, the core of state traditional time-tested police power. So states have the ability and the duty to protect people and property. If states are able to say, we've got to worry about climate change because it's eroding our coast and that affects our people and property, and so therefore we have to engage in global climate change treaties, even if the federal government does it, because as a state, we have to defend our people and property, that they may have a legal argument to push back against the federal government and say, well, we are going to go and reach out for these international powers and international negotiations because you're not doing your job and we have to protect our people. And we have a compelling interest in a traditional form of government. We traditionally took care of our people and the property, and we have a compelling interest as the government of the people to protect them and the property. The federal government's not doing that. Therefore, we are compelled to engage in international action. That's what they're saying. And so basically the argument is, what if California had its own foreign policy? And they point out ways that this may happen. They say, California may do its own things internationally when there's no federal leadership on an issue, or where California comes into disagreement with the federal government, it may say, hey, we have a compelling interest to do this. And the federal government can't say, well, states can't do international foreign policy at all because there's no rule saying that there's only one and only one division of the federal government that can. Traditionally, people thought that it was the president, but they're pointing out that's not legally correct. Congress also does foreign powers. So you can't say it's only bottled up in one office. That argument comes from these scholars here. David Freeman Engstrom from Stanford Law. He is a professor of law and the co-director of the Deborah L. Rhodes Center on the Legal Profession. It's a far-ranging scholar design and implementation of litigation and regulatory regimes. He's been teaching law for a very long time there. The other scholar who is part of this is also from Stanford, Center on Democracy, Development, and the Rule of Law. He's more of an expert in international studies. That's Jeremy M. Weinstein, PhD. Very long-time established expert of political science and international studies. He's also faculty co-director of the Immigration Policy Lab and the Data for the Development Initiative. And this is the article here, What if California Had a Foreign Policy, the New Frontier States' Rights by David Freeman, Engstrom, and Jeremy M. Weinstein. This is in the description, and you can read both. So this, the title of this video covered this title, and there's a link in the description. And the title of this video also covered this one, and there's a link in the description. And that explains how these two documents are showing in our oppression legal scholars using a correct interpretation of the law to point out a California nationalist perspective. Kind of interesting. We'll leave it there. Talk to you soon.